Let's take a look at the Freedom of Information Act. Freedom of information is aptly defined as regulations in law that provide members of the community with a legally enforceable right to access information in the possession of the government. After its initial enactment in 1966, FOIA was significantly amended in 1974, 1986, and 1996, and again in 2007 by the Openness Promotes Effectiveness in our National Government Act, Open Government Act. From its inception, FOIA sought to balance four concerns: open access, privacy, necessary security, and the government's ability to obtain information. FOIA promotes access by giving all individuals a right to information. There's no requirement that they be properly and directly concerned with the information sought. By itself, FOIA is primarily a disclosure statute. However, it instructs and permits agencies to withhold substantial categories of information at their discretion. These categories are called exemptions, of which there are 9. They guard individuals' privacy, trade secrets, and commercial, geological, and geophysical information, as well as to protect government security in the interest of national security, law enforcement, effective decision making and management, and administrative efficiency. Basically, FOIA operates as follows. Activity is triggered by the submission of a FOIA request to an agency. Requests may be submitted by corporations and associations as well as by individuals. Foreigners may also request information. The requester is obligated to reasonably describe the agency records he or she is seeking, that is, to provide enough specificity to enable a professional employee familiar with the material to locate it without undue effort. There has been far more FOIA activity than Congress foresaw in 1966, and effects have been made to prod agencies to process requests more promptly. Today, agencies have 20 days, up to the original 10, to tell the requester whenever the information sought will be released. This can be extended by 10 days to channel the request to the proper agency or unit. When FOIA went into effect, some agencies leveled exorbitant charges for reviewing, searching, and copying. Enforcement of FOIA depends heavily on the federal district courts. The Act places the burden of persuasion on the agency to show the non-disclosure is legal. The district court makes its determination de novo, afresh, rather than being bound by the agency record. There is broad agreement that the implementation of FOIA is costly, litigious, and time-consuming. Explanations vary with respect to why the Act has not worked better. Clearly, the volume and expense was underanticipated.